Big Supreme Court decision in the case of Dukes versus Wal-Mart, Inc. On Monday, the Supreme Court rejected a class action suit against Wal-Mart, which was brought by female employees. It's the largest civil rights class action suit in United States history. 1.6 million women who are current or former Walmart employees charged Walmart with discriminating against women in promotions, pay, and job assignments in violation of Title 7 of the Civil Rights Act of 1964. And here to talk about it is Elizabeth Wydra, who's the chief counsel of the Constitutional Accountability Center, which is a think tank law firm and action center. And I welcome you, Elizabeth.
Thank you, Judith. It's great to be here with you.
All right, so give us just a brief synopsis of the lawsuit and the scope of it.
Yeah, absolutely. So as you mentioned, Walmart versus Dukes is a sweeping class action suit filed nearly 10 years ago on behalf of the more than 1.5 million women who have worked at Walmart since 1988, claiming that they suffered gender discrimination because the company favored men over women in decisions about pay and promotion in violation of our nation's civil rights laws. But this past Monday, the Supreme Court blocked that massive class action, ruling that the women of Walmart did not have enough in common to band together in a class action suit. And this has led some critics of the Supreme Court's ruling to suggest that Walmart, our nation's largest private employer, seems to have figured out a blueprint for low-cost discrimination, delegate nearly unfettered discretion to lower-level managers, and do it on a massive scale. So the bigger the company, the more varied and decentralized its job practices, the less likely it will have to face a class action claim. So forget about too big to fail. We're now talking about too big to sue.
Right. Now, let's just go through some of the discrimination that these women claimed in specific detail. Justice Ginsburg noted that women make up 70% of the hourly jobs at Walmart, but only 33% of management positions.
Right.
That says something right there.
Right.
She said that Walmart's policy of delegating hiring decisions to local supervisors does nothing to prevent discrimination. There's discrimination there. Walmart senior managers often refer to female associates as little Janie Q's.
Yeah.
Hello? Any
that.
problem with that? Anybody? Walmart claims it has worked in recent years to increase the number of women in management from 2005 to 2010, and this lawsuit was started in 2000. They have made some changes.
Right.
They've increased the percentage of female low-level and mid-level managers from 41.2% from 38.8%. And from 2007 to 2010, the percentage of female executives increased 28.2% from 26.7%. And even Betty Dukes, who was the original woman in this case, the 54-year-old Walmart worker in California, she did acknowledge that conditions improved at her store after she first filed her lawsuit in 2001. Why is this decision so important, and what does it mean in terms of the rights of workers across America?
Right. Well, I think it's really important to note that while this decision isn't about whether or not Walmart actually discriminated or not against its female employees, that those rulings can still, that issue can still be litigated. But
where is that issue going to be litigated?
Well, so this is the problem. So the Supreme Court's ruling closes the courthouse doors to the group of women banding together. And, they were seeking a company-wide solution to a company-wide problem, which makes a lot of sense. But with only individual lawsuits left as the women's potential avenue of redress, it makes it difficult if you're, a David or Debbie versus Goliath going up against a major company.
Right. And what lawyers are going to take cases like this?
Exactly. Class actions, certainly get a bad rap, but in the public, but they are critical for victims of discrimination or other corporate misconduct who may not have the means to bring their own individual lawsuits. Many of these Walmart employees earn modest wages, and joining individual claims together also allows for a fuller picture of widespread patterns of discrimination to go forward. So it can be very hard to prove this kind of subtle old boys network kind of discrimination just on your own.
Right. But the Supreme Court ruled unanimously that the case had been improperly filed. Okay.
Yes.
And they said that the lawyers basically would have to offer stronger evidence of a nationwide practice or a policy that hurts this class.
Well, actually,
so explain that a little bit.
Yeah, so Judah, that's a great point, and it's important to recognize that there was a part of this ruling that was unanimous among the 9 justices, but that was only the technical question of whether the female employees' request for back pay, that they would have gotten had there not been discrimination, was properly filed under a class action provision of the Federal Rules of Civil Procedure that normally provides only for non-monetary relief. But in the heart of the case, it was split 5-4 with the conservatives in the majority. And the heart of the case is the fight between Justice Scalia and Justice Ruth Bader Ginsburg over the fundamental question of whether there was a single question of law or fact common to all the women in the suit that would allow them together to press their claims against Wal-Mart. So on that key point about the commonality of their claims against a single Wal-Mart policy, on that point, the justices were divided 5-4.
Mm-hmm. Now, in terms of the effects of this ruling, what will happen to this case? Will they break it down into smaller lawsuits? How do they move forward with what appears to be a legitimate complaint?
Yeah, exactly. So, there are 3 basic options. One is just pursuing the standard individual discrimination claim. Betty Dukes could file on her own against her own particular manager. They could bring smaller class action lawsuits so that, smaller class actions that could focus on one particular region or one particular store instead of, the entire Walmart operation. And they could try to file claims with the federal government's Equal Employment Opportunity Commission. But, with all of these, there are certainly some drawbacks. As we talked about before, it can be very difficult to afford a lawyer. When you're talking about sort of a management position from being a floor worker to a cashier, it might not be a lot of money you're talking about individually, and so it's going to be hard to get a lawyer, unfortunately, to take that case.
Yeah, I mean, litigation in general in this country, unless you have this sort of class action suit or unless you find the rare lawyer who will take cases on like this, is so astronomically expensive. And the resources that these big corporations have are limitless, and there is no way that any individual can compete with it.
Right.
There's just no way, right?
Yeah.
Unless you have these class action suits. How does your average person who's working at Walmart for $8.75 an hour, right, which is the average wage,
right?
How do they compete with the CEO whose annual salary is $35 million? He makes $16,826.92 an hour. And then, of course, we have the Walton family, number 4, number 8, number 9, and number 10 on the Forbes 400 Richest Americans list. Christy Walton and family, $26.5 billion. Jim Walton, $21.3 billion. Alice Walton, $21.2 billion. S. Robson Walton, $21 billion, all off the backs of millions of people worldwide, who are very often don't get paid rest or meal breaks, who are paid very small salaries, who are treated in this fashion. Like, something has to give here when we're looking at these disturbing trends in American capitalism and the fact that these companies have so much power that the effect of this ruling basically diminishes what America is supposed to stand for.
Yeah, absolutely. And, I think, when you're talking about sort of American values, we all have this American value of equality and equality of opportunity. And we hope that is true, for all Americans, all workers, all people who are here. But there remain subtle forms of discrimination as well as overt discrimination, and it can be nearly impossible for an individual when they're faced with a giant like Walmart to prove this more subtle old boys network kind of discrimination. I mean, the lawyers for the class, for these millions of women in the class, spent millions of dollars on studies, getting statistical analyses that, one woman, in rural America could never have the resources to come together and prevail on her claim on her own. So, it is a disturbing trend that the Supreme Court has really cut back on the ability of everyday Americans to hold major corporations accountable for misconduct.
And also, the corporate dominance now that many of these corporations have over American diplomacy, over government affairs here, over, the lives and decisions of politicians. This is something that really requires a closer look by all of us because, the decisions that are made on a day-to-day basis by the people that we elect are often, informed by corporations.
Right, and perhaps even more so after the Supreme Court's ruling in Citizens United last year that allowed corporations to spend unlimited amounts of money in
supporting candidates. Right, yes. You can spend anything you want. You can basically go out and buy any candidate you want. And of course, the media is largely controlled by people who have the same kind of agendas, right? And it's very difficult to find journalism today that's uncompromised. Very, very hard. Very, very hard. What can we do about it?
Well, I think with respect to the particular issue of class actions, and the ability of the people to band together in the face of massive corporate discrimination or other misconduct, Congress can do something about it. And, in fact, House Minority Leader Nancy Pelosi has called on Congress to pass legislation that would effectively reverse the Wal-Mart decision. And that I think Congress really should take a look at what they can do on class actions in particular, and in other ways they can rein in corporate misconduct. But, some of these decisions by the Supreme Court, like the unlimited campaign spending decision, are based on the Constitution. And it's a fundamentally flawed vision of the Constitution that privileges corporate rights over the people's rights. It's we the people, not we the corporations. And so I think that we as citizens really need to keep a close eye on what our court is doing in our name and really push back against that.
Yeah, and in terms of individual citizens, if you're offended by a decision like this, if you're offended by the practices of Walmart, stop shopping there. And, you might think you're going to save money. Don't buy the stuff, right? Buy less and don't shop there, and support your fellow man, and the kind
and
of
woman.
And woman. I say that as a generic fellow man. But, the discrimination is just the tip of the iceberg here because individuals have to take back the power, right? We can't rely on the Supreme Court. We can't rely on the legal system for sure, because it lets us down over and over again. And we have to take matters into our own hands. And every single person can affect this. Stop going into Walmart.
Yeah, I mean, certainly boycotts are an option, but I would hope that we there are many in the judicial system who are standing up for justice. And, Justice Ruth Bader Ginsburg is an excellent example. As a private practice lawyer, she won many of the cases that have set equality for women as a constitutional principle. So I hope that it will swing back to having more people like Justice Ginsburg in the seat of power on the court and in elected office as well.
And in the meantime, don't shop at Walmart.
Yeah.
Do what you can. And that's your little silent protest. Go somewhere else and buy your stuff.
Right.
All right. Elizabeth Wydra, Chief Counsel of the Constitutional Accountability Center. Thanks so much for being here.
It's my pleasure. Thank you.
Thank you. It's Judith Regan.